On September 11th, 2001, the nation was under attack.
A few minutes ago, we're told that a plane crashed into the upper floors of one of the Twin Towers.
There are two, that both Twin Towers now are on fire.
The World Trade Center has collapsed.
After the death of 3,000 people, what it means to be an American, and the liberties that come with being an American, would never be the same. On the night of September 11th, George W. Bush delivered an historic address to the nation in which he gave an inspirational quote on the shortcomings of the attack.
These acts of mass murder were intended to frighten our nation into chaos and retreat, but they have failed. Terrorist attacks can shake the foundations of our biggest buildings, but they cannot touch the foundation of America.
Wait, one more time.
The foundation of America.
Okay, pause there. So what exactly is the foundation of America? Many would say it's
the Constitution.
Constitution. The Constitution.
Our Constitution.
The Constitution of the United States.
I would also agree that it's the Constitution. In 1791, a Bill of Rights was added to state which rights you had that the government couldn't take away. The rights that they listed were usually based off of injustices that had happened to them under the British government. In 1750, American colonists were smuggling in goods in violation of British law. In reaction, King George III granted British soldiers the ability to indiscriminately search colonial homes under the authority of the writs of assistance.
The Fourth Amendment arises from the abuses of the British Crown. Instead of following specific allegations against specific individuals, the Crown's revenue agents were given free rein to search indiscriminately.
James Otis, a colonial lawyer, would later challenge these laws and their legality under the British Constitution.
That's why we got the Fourth Amendment. The Fourth Amendment was the product of a decade or more of James Otis arguing cases against the British government.
John Adams would later regard these cases as a spark that set the revolution going. The Fourth Amendment now reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." So what exactly is probable cause? It's commonly defined as what a police officer needs to obtain a warrant, a reasonable belief that someone has committed a crime.
I just don't want anybody to be able to walk in my home unless they have probable cause to enter my home. There has to be some form of illegal activity in my home, or they had to reasonably believe it and be able to prove it, because everyone needs to remember you've got to have the proof.
And that proof can be as strong as DNA evidence to as weak as hearsay from a reliable source. Probable cause requires more evidence than another standard of proof called reasonable suspicion, but even that has to be more than just a hunch. This is when an officer reasonably believes that someone has been or will be involved in criminal activity. In determining this, they can't use race or ethnicity, refusing to answer officers' questions, or refusing a voluntary search. In certain circumstances where there's a great amount of probable cause or reasonable suspicion, or another emergency circumstance, a warrant might not be required. One of these circumstances is a stop and frisk search, where if an officer has reasonable suspicion that someone might be armed or might be involved in criminal activity, he can hold them aside temporarily for questioning and a pat-down. This method has been routinely controversial because of its seemingly disproportionate application on African Americans and other minorities, like in the event of Michael Gerardotti, an NYPD cop who searched an African American gentleman because he was African American.
Gerardotti was reportedly using the NYPD's stop and frisk policy, which only requires an officer to have a suspicion that a crime is about to be committed. The NYPD defends stop and frisk as a great crime-fighting tool, but it's a policy the Center for Constitutional Rights has been speaking out against for years because of the number of Black and Hispanic residents who are targeted.
Another type of warrantless search is under hot pursuit, where if an officer is pursuing someone who has committed a crime, they can enter any building that person enters during the pursuit.
If I'm witnessing a crime from outside in public view, I have the right to enter the house and stop the crime.
There are also emergency circumstances, where if the officer is certain that evidence will be destroyed, if he takes the time to get a warrant, he doesn't need a warrant to search.
When we know that we've had situations where we knew that the drugs were going to be disposed of, and when I mean disposed of, they can be flushed down the toilet, they can be poured down in the tub, the sinks. I mean, there's a lot of different ways to dispose of them. Plus, they're also dissolving when they go down. So, and it can affect your case.
In the past, the Supreme Court has reached the conclusion that there should be a balance between the intrusiveness of a search and the probable cause needed to justify it. The more intrusive the search, the more probable cause should be needed. This balance allows searches to be reasonable as required by the Fourth Amendment, but since 9/11, the line between the two has become more and more blurred.
Well, our position is that any search has to be reasonable. Now, the Supreme Court has said, and this is really pretty much the way I think it has to be, that reasonable depends on some sort of balance. Government should not be doing things that are unnecessarily intrusive. If there's a body scan or something that is so intrusive, possibly, and I think this is not beyond question, possibly having health consequences, and that is not really necessarily giving us that much in return, then we might regard that technology as being unreasonable.
On October 24, 2001, Congress introduced a new bill, the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism, or it is more commonly known, USA Patriot Act of 2001.
This government will enforce this law with all the urgency of a nation at war. The elected branches of our government and both political parties are united in our resolve to find and stop and punish those who would do harm to the American people. It is now my honor to sign into law the USA Patriot Act of 2001.
Although it was passed almost unanimously in the Congress, the Patriot Act remains one of the most controversial pieces of legislation in America's history.
Patriot Act, the most abominable, unconstitutional, hateful, from the point of freedom, piece of legislation since the Alien and Sedition Acts in 1798.
Now that may seem like a bit of a harsh statement, but there are some sections of the Patriot Act which are extremely questionable and almost certainly violate the Fourth Amendment. Like Section 215, which says the government can force any third party to release any tangible thing, including books, records, papers, documents, and other items to aid a terrorist investigation. This can include medical records, library checkouts, or even bank transactions. The Patriot Act also says that if the government does order for the release of certain tangible items, the person who received the order cannot tell anyone, not their family, not their lawyer, only the people who could help them get those tangible things. This gag rule has been ruled unconstitutional in several courts, but is still in use across the nation. Section 213 of the Patriot Act allows for something called a sneak and peek search, where the government, if it feels necessary, can delay letting someone know that their house has been searched, if they feel that doing so would have an adverse result. There are many that say that while these laws are harsh, we need them in order to make terrorism investigations more efficient. But do they? The warrants that the federal government issues to perform searches are called National Security Letters, or NSLs. In 2001 through 2005, 192,499 NSLs were issued, leading to exactly one terror-related conviction. For that same span of time, only 9 national security letters have resulted in 11,100 U.S. citizens' phone records being released. As for sneak and peek searches, in 2010 alone, there were 3,970, and of all of those, less than 1% were terrorism-related.
I think there was a whole mindset that everybody was persuaded to adopt after 9/11 of a sort of better safe than sorry, and that we have to give up our liberties in order to be safe, and therefore you shouldn't complain if people want to search you or if there are intrusive security measures. However, giving up your liberties does not in and of itself make you safe. So I think that before people are willing to go along with a sort of a program, even very invasive programs like body scans or frisks, I think we should be asking some questions about what we're really getting in exchange for that program.
Terrorist attacks can shake the foundations of our biggest buildings, but they cannot touch the foundation of America.
Why do we defend America? Why are we protecting it? It's because of our liberty. And when we implement policies that take away our rights in order to defend our country, we find ourselves in a dilemma, because we are no longer defending liberty, and we are no longer defending America. I guess there are some things worth holding on to.